Well, welcome to this seminar workshop on patents. And today, as kind of an extension to what we had done earlier, we're going to talk about how you can write your very own patents. Now, before I begin, I wanted to give Ms. Yip copies of the overheads, and I wanted to kind of reiterate a couple of the things that I said earlier today about what this is all about. First of all, can anybody tell me what an invention is? An invention is what you do. If I took a piece of paper and folded it into a paper airplane, that's an invention. And a patent is merely the grant of the government to give you a right of exclusion over the use of the invention by someone else. You don't have a right to use your own invention, but you have a right to exclude others from using the invention. Basic property rules. All right. Now, what we're going to do today is, and I wish this were easier to pull apart. I'll just use this. What we're going to do today is we're going to learn how a good patent attorney thinks about an invention, and this will make your job and his job easier. I want you to take attention to this book. This is a book that's published in the United States by David Pressman. He's a former patent examiner. Patent It Yourself. Patent It Yourself was a book written for the individual inventor as if if the individual inventor wanted to turn himself into a patent agent. It's available at numerous bookstores in the United States. It's available directly from the publisher, Nolo Press, which is a well-known U.S. do-it-yourself publisher, and from the Sunnyvale Patent Library, which is a Sunnyvale Center for Innovation, Invention, and this is its email address. And I'll turn off my computer now that I've got all that information. They have a fax. It's 408 735-8762. And use my name. They know me there. You might get a discount. This is a very interesting library. It's a branch of the Sunnyvale City Library System, and it has become a center in Silicon Valley for individual inventors to do searches of their inventions. They have a broadband link directly to the patent office into the search system of the patent office, and you can go in there and actually search the online database that is used by the patent office. They also have access to Dialog, which you can have access to if you have an account, but they charge, I think, like $100 an hour, and then the Dialog database is comparable to that. If you had the time, you could go there, but you're not going there now, right?
Question, what is the difference between that database and the one that we could access via the web?
The one via the web is just a copy of the patents in images. The database in the United States Patent Office is word searchable and also image searchable and also classification searchable. It's set up so that you can actually page through the classification just as if you were in the patent office on an electronic database. Now, the one that's on the web is just you look up a number, you look up a name, and you might be able to get everything according to an existing class on the face of it. But it isn't as organized, doesn't have the indexing that that one does.
I think it has the keyword search too.
Yeah, keyword searches are available on both of them. Keyword searches are available on both of them. My experience is that keyword searches are less effective than classification searches if you can get at the classifications. So when I do searches or have searches done, I usually engage one of our associates in Washington, D.C., who goes and talks to the examining corps with the written description of the invention and say, okay, where do I look? And that's where they look. That's the class and subclass. And the time they spend on it is usually fairly limited. They may spend, maybe 2 or 3 hours at most to do a preliminary patentability search. It's not a very effective way, but it can be effective if your invention is fairly focused and you're looking for inventive concepts. All right, now, given that, I want to go over some of the things that you would need to do if you were writing a patent application. And if you will take this sheet, each of you has this, okay? Did you want one? This is a set of guidelines that we give to our young patent attorney associates to teach them how to write a patent application on behalf of an inventor. And these are just the mechanics that we go through in trying to write up a patent application. Earlier, Kit gave you a version of this in his slides. I don't think it was included in his handout material, but he did have a version, something like this, in his slides. When you're dealing with an invention, what you're trying to do is you're trying to take what you did and abstract it to its broadest application, its broadest concept. If I could think of a good example. One of the patents that I got, the simplest patent that I ever got for anybody, was on a plain piece of mylar. Now let's assume that we don't have any. Let's assume we don't have any writing on this. This mylar piece was about 11 inches, a little more than 11 inches long. But the concept of the invention was to roll it up, hold it, and heat it. And using the natural temperature sensitivity of mylar and the memory of mylar when you heat it, when it was heated up, it'd form a natural curl. That natural curl forced it to want to roll up after it had been heated. What was this invention for? It was a keyboard dust cover for a computer. Now, that simple invention was claimed in terms of the material in its environment with particular characteristics. I didn't just claim a piece of mylar, I claimed a piece of material having a particular ratio of dimensions matching the form factor of a computer keyboard, having the characteristic that it had a natural curl to it, or a curl caused by memory. Now, this is an example of how you try to abstract an idea into a claim which is patentable. Patents issued, it's used as a kind of a promotional tool by a company if they want to, put their name on it and say, okay, it's just like a mouse pad, it has some advertising on it. And they give this away. It's great promotion, very cheap to make, but it's a patented invention. So, first step you want to do when you're considering your disclosure material, or whatever material you have. Now, as inventors yourselves, you will probably have the disclosure in your head. You want to identify the inventive concept, what it is that you actually did which differs from the prior art. So that means you got to know something about what the prior art is. You need to know what benefits are created by your inventive concept, and you need to be able to then abstract and consider if there are other important principles in this inventive concept.
Excuse me, Jeff.
Yes.
I think we have a very specialized group here.
Okay, we could answer specific questions.
We can, well, I mean, whatever we talked about, maybe we can cater specifically to software patent.
Okay.
System or information.
Well, let's.
Technology, information.
Okay.
In the communication.
Right.
Yeah, so we can talk in that environment.
Okay, within the environment of data communications.
Wireless
Software. Well, everything happens to be have some sort of an embodiment. It could be its software. You could have wired it too. Could be in an ASIC. So what you do is you don't claim it as software. You don't claim it as hardware. You claim it as a means plus a function. It's a means plus a function. Means responsive to a signal for the purpose of creating a certain function. Why don't we can work on this. The first thing we do, as I say here, is you create rough drawings so you have some idea of what the invention concept is. I'll take suggestions for an invention you'd like to see explored. What do you think? What have you done that you'd like to see?
Search engine.
A search engine.
Of algorithm to search information. On the
Okay. We're going to treat that as a process. You have this black box. You have a query. You have a database, which is the net. And it happens to be a quasi-flat database, right? Could be indexed someplace.
Not completely flat. This is all highly indexed.
Highly interlinked. Now, somehow in here, this search engine needs to know how to respond to that query, to look out here, and I assume that are you assuming that this database is indexed or unindexed?
In real life, it's indexed.
Okay.
The web is actually a lot of pointers among different web pages.
Now, is this search engine comparable to, say, Alta Vista?
Similar functions, but capabilities are not identical.
Okay. So we have prior art already. The Alta Vista search engine, which you probably understand much more than I. So that's prior art. You're going to have to look for an improvement over the Alta Vista search engine.
That is more like a keyword search. Ours is a more associative search.
An associative search engine, huh?
Well, it's not exactly matching the keywords. Yeah, this is not public disclosure.
You didn't disclose the detailed algorithm.
You don't have to disclose the detailed algorithm. We are on tape. We are on tape. So what you might do is say, okay, you can talk about one that you're not going to pursue, and we could use that as an example.
Well, so far I didn't give you any detail.
Okay. Okay, now the question I will ask is, are there other associative search engines?
Not that we are aware.
Okay.
Not the way we are doing it.
Okay, so the specific implementation of an associative search engine is what you want to pursue. Now, this is software. That means that you're going to be able to generate as much as you despise generating it. An IBM-style flowchart. Patent offices love flowcharts. If you can take your algorithm and express it in steps like this, this step, this step, this step, this step, and potentially this step together are the basis of your claim. I've just generated a diagram of a process, and the particular elements of the process represent every element of a claim. The next issue is, can we abstract beyond that? What is, you undertake a particular type of process here. What's a generalized statement of that process? Now, that means that you can actually generate two flowcharts, one with the particular steps, one with the general steps, but having exactly the same topology. And I would draft two claims, one to each of those. Or I would draft two claims, an independent claim with a generalized version and a dependent claim in which I say this step is actually this detailed step, or this step is that actually that detailed step.
Yeah, actually, I think maybe before that, there's still some question in my mind which I'm not quite sure. That is about the focus of the application itself. That is, if you look at this idea of the associative search engine, there's a part which is very clear to me, which is the actual algorithm itself, and which is, I can put it in the flowchart or whatever. That part is quite concrete, and it's somewhat mathematical because it involves a lot of symbols and so on. Now that part obviously maybe was a candidate for the application, like for the patent application. Now, but on the other hand, for example, this idea of associative search, is that something it has any value? I mean, is that it seems to be like a very general idea.
It's a very general idea. If you are the very first person to have come up with the concept of an associative search, then we define what is an associative search, because you've invented the word, you've invented the term.
Actually, yeah, I know I've not seen it. But I won't be surprised someone else somewhere is a similar idea.
Yeah, it sounds very artificial intelligence-like.
By itself, may not pass the what do you call it, the innovate, or what do you call it,
the novelty.
Trivial, obvious art. I mean, because people who works in this area, if they think about it, they may come up with something similar. But I mean, there probably is not any, not yet any applications, other applications.
Okay, so there may be some theoretical basis for this that you're.
Because the direction there may be there, but actually, how do you do it? It's not completely trivial, right? It's not trivial at all. So people elsewhere may think about this idea in general, but they may not have a way to do it. But now actually we have this idea, but also actually have a way to do it. Okay, and do it on the network, on the web. So I don't know if there's so many components. I don't know which is the, from your viewpoint as an attorney, what do you think is the best way to position an idea like this?
Okay, this is a strategy on claim drafting. My general rule is you want to get as broad a claims as you're entitled to, and then layer them and have more specific claims to specific concepts. If you can come up with some generalization that says, I claim associative searching because you can't find anybody who's ever done associative searching. Or I claim associative searching over a network which has these characteristics. That could be the distinction. And you just kind of layer it. Now, the alternative strategy is to say, in a system for associative searching, a method for creating an index or a method for querying the network comprising the steps of, and then you have that minimal set of steps which constitute the core of your invention. I call that the silver bullet approach to patent claim drafting. All you want is that one silver bullet that everybody wants. You don't have to disclose everything about how your system works, so long as you disclose that silver bullet and say, given this environment, which you can look up someplace or somebody uses, if you use this one little feature, then it becomes a patentable invention. I'll give you an idea of one of the patents that I wrote, which was one of the patents that is now being used as an example of a good software patent. It's one related to artificial technology. I wrote it about 15 years ago. It was an inheritance mechanism for an artificial intelligence engine in which the inheritance was actually explicit in terms of the attributes of the system. So that was written in terms of a method for passing on inheritance attributes. just in a method of inheritance. And it was it didn't have to be a software, limited to software. It could have been in hardware, but we claimed the method, and we got that one through the patent office. Now, we also attached a listing, source code listing of this particular invention, and that often becomes important in a software patent where the only implementation is in software, is to take pseudocode or the actual source code and include it in the description of the invention, in what's called the detailed description portion. That way, especially if you use actual code as part of the disclosure, there can be no question that you've disclosed the invention, because all I have to do is copy it into a computer, execute it, and it works. Pseudocode is probably more practical, because then you can use the pseudocode to comment on how it works, and you're simply writing out in a pseudo-C language what you're doing. You don't have to necessarily have all the parameters with all the proper calls, but you can write it up in pseudocode, put it before the attorney. Maybe he can understand it, maybe he can't. You're going to have to thoroughly comment on it so you can figure out what each of those steps are. And depending on how detailed you want to claim it, you have more detailed pseudocode. I mean, you could have a pseudocode line that says, go get a sin x over x function and return the results from these arguments. That's all you need. You don't have to explain what the sin x over x function is and the fact that it blows up when you hit 0. Because it's a library call, and it's a fairly well-known function.
Is it beneficial to the applicant to do that specific?
It is beneficial for a number of reasons. Number one, well, again, it depends on what you want to claim. At the level of detail of your specification should correspond to the level of detail of your claim. There are some patents that you will find which have a huge amount of detail, and maybe one claim. I call to your attention the patents on emycin from Technology. I don't know if you're familiar with those. Technology had a bunch of patents that issued. We looked at those claims. They were so narrow. And I said, why are these guys trying to enforce this patent? No one wants to practice it this way. But that's what they got through the patent office. But in order to support that one claim, they had 35 pages of very small single-space double-column type. Very expensive patent application. My IntelliCorp patent was 8 columns. Very short.
I do have a question. I think when you're building a system like that, obviously you will have components that perhaps is not derived from you. For example, like let's just say compression, data compression. You might have to do that. Okay. Now, my question is, when you actually put different components together, can that be patentable?
Yes.
But not, I mean, okay, let's put it this way. Data compression, you didn't invent that. You might use some, and image processing techniques, you might not, you might, take it from the book. But it's the way that they arrange these pieces together to have an overall function. You think that is patentable?
Yes.
Okay.
And let me explain why. All inventions are made up of old elements. Those elements may be really elementary, like atoms, but typically they are made up of components which existed in the past. Some exceptions, but in almost all instances, you're not creating, at least in your field, new compositions of matter. You are using a data compression engine, output drivers, whatever. So long as you can identify those components and relate them to something that is readily available in the art, you satisfy the requirement of adequate disclosure. Your invention in that instance resides in the combination of those elements. And typically you don't include the input and the output in those combination of elements, but in the combination of those elements, in their arrangement and in their interaction. Because then you say, look, I took elements A, B, and C, all of which were known in the prior art. But in the prior art, no one thought of using A to produce an output to feed B, which in turn uses its output to feed C, because it wasn't thought that they would ever work together. I mean, now, sometimes you do come up with a modification. And often it's that modification which itself is a patentable element. And you could pull this out and claim B prime as a separate invention. Yes?
Follow up on that. What happens if, say, A is already patented by somebody else?
So what? You're dealing with advances in the art. The fact that it exists before, whether or not it's patented, has no impact on whether or not you can patent it. It may have some impact on your ability to practice the invention.
Unless you make money, then A was going to come and claim against
Right.
you.
But remember, patents are only enforceable in jurisdictions where there are patents.
So the fact that we are including it in our patent doesn't form an infringement
No,
on the other guy.
it doesn't involve an infringement. It might call attention to the other guy that you're using it, but so long as you or the potential user obtains rights to A, assuming that it does have some rights, you're free to make the invention. And this brings up the instance where you get into what I call a Mexican standoff. You have two people, both with guns ready to shoot at each other, and if either one of them shoots, they're going to kill them both, and so it doesn't do any good for anybody to shoot. So when you're thinking about obtaining patents, you don't worry too much about use of previously patented subject matter. If you can come up with a list of substitutes that will work in here, Q, R, S, instead of just A, and you disclose those, and they work almost as well, you have also taught to the world how to practice the invention without using someone else's proprietary technology.
But that if you specifically need to use A for licensing purpose, then you do need to get a license from the A's only.
Yes.
Two questions. One is that this will be considered as a process or method?
Process and method are the same thing.
The same thing, okay. Another one is if you reverse the order of B or C, B and C, would you call it new? Can you patent something new based on that?
Good question. Very good question. If there is a process or a method which requires a sequence of the steps in order for them to work, that is one invention. If you have discovered a way so that you can change the order of those steps, that is also another invention. However, it depends on how the claims are written. Claims are often written stating particular processes or elements forming processes or sub-processes without a description of what the order is. It's only if the claims say that they have to be performed in this certain order are they limited that way. So in claim drafting, if you have to use steps A, B, and C together, but it doesn't matter what the order is, all you need to say is, I do step A, and I do step B, and I do step C. And in software, that happens a lot because you have parallel processes going on all the time. These flowcharts, despite what IBM teaches us, are not really sequential, except when you get into, you're dealing with a single CPU and you have to order your processes. But often it's not important whether this step precedes those two steps. It could take place down here. So in claim drafting, you often draft it with that in mind, and only under circumstances where you want to make it clear that it can have a specific order do you actually specify the order.
A related question is that this morning there were 3 criteria to satisfy utility, novelty, and non-obviousness. To me, it's very difficult to test in the reverse order. Utility is relatively easy, novelty depends, and then the non-obviousness depends on the reference you choose. If you have already known A, B, C in this order will work, if you reverse the order a little bit to those who invented this ABC sequence, this is quite obvious to them, but for the rest, it may not be very obvious. And also to the experts who work in the area, it may be very obvious, but to others, it may not be very obvious. So how to test? What's the real feeling you can pass on to us about what is obvious, what is not obvious?
It's obvious, don't you?
Yeah, obvious, I don't know. Obviously.
The obviousness standard is a semi or quasi-objective standard. And in application, something is new if a single reference, if there is no single reference in all of the published literature which describes all of the elements of the claimed invention. That's the standard of newness, novelty. Non-obviousness is no combination of references where there is a suggestion of one to use the other contains all of the steps of the claimed invention. Obviousness standard is a person of ordinary skill, not an expert, but a person of ordinary skill, a technician, who doesn't have an original thought in his body. But this technician has all knowledge of everything that's ever been published. So that's why this suggestion is so important. If this has A and this has B and this has C, but this one does not say, or this one, I'll give you a clearer example. It says, don't use C. If you have got A, B, and C together, you've got a patentable invention. It's non-obvious because you found a reference that says don't use C. And even if there's a reference that says C, because it says don't use C, the examiner in judging the prior art looks at these things and he makes a statement. He'll say, well, it does suggest it. When you point out, oh, well, there's this line down here that says don't use C. Therefore, this is an improper application of the obviousness standard. Now, sometimes you'll see an obviousness rejection where there is C is a part of the state of the art. It's just out there. Everybody knows about C. And A and B exist, and there's no statement about C one way or the other. An examiner will say, well, a person of ordinary skill in the art, having knowledge of this reference, would have known to use C because it's such an obvious thing to use. Now that's about as subjective as the arguments get from the patent office. He says it's out there. Now that's hard to argue against. So what we do in our prosecution, in our processing, in our negotiation, is says, okay, if C is out in the state of the art, you find me a reference which says C is in the state of the art, and you show me how C can be used with A and B. Force the examiner to prove his point. And that happens a lot.
How do you define state of the art?
State of the art is the existence of typically publications. It could be subject matter that is on sale, typically not when you're going through an examination.
When you talk about a field where new, like in the internet, it's not that much.
The internet's a really tough one to deal with.
Well, state of the art. Because, go back to my example, associative. Associative is not new in some circles. Neural network, all these things. In for example, more traditional setup like memory, you have associated memory, all those things. So when you apply it to the internet, is that itself new, or do you need what kind of state of art can you use as a standard in this case?
Would a technician have thought of doing it that way? Probably not.
A technician working in the internet, not a technician working in some other discipline.
If the technician has read everything in the literature, he will know that.
He would not
nobody be
necessarily,
able-
you got to look, does that technician have to use one iota of creative input? He's got to be able to find that teaching, to do it this way, on the internet.
See, but the thing is, if you talk about a technician currently working on internet, who never heard of associative memory, so that may not be something that's too trivial to him. But if you take someone, a technician who's working in a different field, and you put him in internet environment, maybe he
Maybe not. And this is often the issue that arises. Is this environment different enough that you could claim something that already exists in another environment? And that's an issue that has to be resolved on a case-by-case basis.
That is the gray area.
That's a very gray area. It's a very gray area. And sometimes, if you can get the claims, if you can convince an examiner says, this is an unrelated art. Somebody working in the internet area wouldn't go to this remote art to do this. Now, in your particular case, it would be kind of, you have associative memory, you have associative databases, you have, would someone working in the environment of the internet think of doing this? On the other hand, they may say, okay, we have someone who's working in database management areas. Is it a trivial extension to take all the principles that he has in database management and apply them to this weird infrastructure called the internet? Now, someone working in database management systems is probably not going to be familiar with the challenges of dealing with this weird infrastructure of the internet, whereas somebody working in the internet may not be familiar with the principles of associative data processing. And so your invention is saying, okay, we've got this principle over here of associative data processing, and we understand the challenges of the internet. We've been able to marry these two. That's the advance in the art. You have added to the body of knowledge of the art by figuring out how to take this technology and marry them.
One case maybe I think from which I can learn a little bit about what is obvious, what is non-obvious. If 20 years ago or some time ago, before the cellular communication took place, got started, if I patented, I try to apply for patent for cellular architecture, which I think is very powerful, although it's a very simple idea. Would I be able to get it?
Yes, 20 years ago. In fact, there are lots of patents
On cellular architecture?
on cellular architecture. There were at least, I think,
right? Okay.
at least a half a dozen different proposals for particular cellular architectures, all of which were subjects of patents.
But this is a quite obvious.
Now, because it's now part of the state of the art. I mean, you've grown up with it.
Because we teach wireless, that is a
Right.
thing you need the least
Sure.
explanation.
I mean,
You
see,
say,
the
I
hard
wanna
one.
take it.
The hard one is the microcellular architecture.
Mm.
The microcellular architecture, where you have these little, basically 900 megahertz, 100 square foot or 100-foot radius telephones, and they're turning it into a cellular system. I mean, what's patentable about that? Maybe it's in that. Maybe it's in the particular protocol to be able to handle that density of traffic. And there are lots of protocols that you have to deal with when you're dealing with microcellular architecture.
So you can patent the big idea of cellular, just have base station, so that the mobiles communicate with the base station instead of with each other.
Mhm.
That just very big.
At
General
one point,
idea
yeah,
is
there are
possible.
patents on that.
Is
There
that
are
right?
actually patents
okay.
on that.
It was a profitable patent because everybody using it.
20 years. That
Is
was expired.
Motorola a profitable company?
Last quarter, no.
I think they are. I think they are.
No, okay.
Now
They had a patent.
they have a patent. They have a very active licensing program too.
Okay.
And I think they use the cellular architecture in their paging systems, and they have locked up the paging technology. Yes.
I have a question. Going back to what you just said, protocol. That is patentable.
Yes.
Let me just give you an example. Okay.
Mhm.
Say plugin architecture. I mean, everybody is saying plugin architecture. If I have a program that I could also use a plugin, the buzzword plugin architecture, but how do I define it? That's a protocol problem, correct? Because plugin could be in Netscape, it could be in Photoshop, it could be something else. You're saying that protocol for the plugin architecture, that is patentable or possibly patentable?
It's possibly patentable. Often the network protocols, and I work a lot with 3Com, and we've done a lot of work in packet communication protocols dealing with control at other than the standard ISO layers. And we've gotten lots of patents in that area. So they will do protocol processing out of what is the conventional layer, and it's very difficult to claim that because you have these controls at one level, and what they've done is they've moved it to another level, and they've been able to speed up their processing. But protocols definitely are patentable. Now, here's another issue, and this is a side issue. When you get involved in telecommunications, where you have to deal with other systems, and you have a patent position on something that is required to be used by others, and it needs to be adopted as a standard. Even though you have a patent on it, in order for it to be adopted as a standard, the standards setting agencies have decided that you as a patent owner must grant rights to others to use that technology on a reasonable and non-discriminatory basis. And so, if there is a standard for paging, Motorola has to license it. It could, of course, build its own system. And some small companies like to see their inventions adopted as standards because then it gets broader exposure, much broader exposure. It's better to have 0.5% of $1 billion market than 100% of a $0 market.
So usually in the standard, they say this particular item or proposal or protocol is patented out there of somebody, right?
Yeah.
Usually it's there's a footnote saying that you don't have to worry about you don't have to search everything out of a standard to see.
If you're dealing with a standard, or you're writing to something that fits in a standard, and even somebody who has some proprietary rights, you can get the license. They have to grant it if it's part of the standard.
But some people, like a Qualcomm license, is very expensive. It's not something that that's very.
I know.
usual,
I don't know if it's a standard or not.
Yeah.
I don't know if it's a standard or not, but it is in principle. It's reasonable and non-discriminatory. If everybody pays the same amount, it's a level playing field. It just happens to be a higher level.
In some wireless standard, a lot of patents are given for free. Is that a common practice or it's
to give it away?
Yeah, like a CT2 common air interface. Because a lot of the previous work was done by a consortium.
I think that is a decision by the consortium. CT2 is one of those digital standards. Because it's done by a consortium, the consortium can make a decision that they can grant free licenses under that technology because they figure they will benefit from the sales of products that are sold under that standard greater than they would from the revenues that generated from licenses. In fact, just a side story on that, I got a call the other day from somebody who said, I'd written a patent on a CT2 product, and they called up and they said, some law firm said, we have an anonymous client who is very interested in acquiring your client's patent on CT2. It's just out of the blue. Somebody calls up and says, I want to acquire this patent. Well, we'll see what happens.
What does it mean by acquiring the patent?
Purchase it.
Oh, I see.
Purchase all of the rights. Become an assignee of the rights of the patent.
But what I'm trying to say is that U.S. government, they has patent saying this is the person inventor. That will always be the inventor. I mean,
that will always be the inventor. The name of the inventor under U.S. law, the person who did the work is always the inventor. But the ownership of the rights may differ.
But in CT2 case, what actually is being patented?
What
Many patents.
There are many patents.
Pieces.
Many pieces of this.
Basically, if you look at CT2, it's just a combinations of a lot of very standard technologies.
Yeah, well, sure, it looked like a combination of all these standard technologies when you look back on it, but there are various implementations of it which required some innovation for which people got
At that
patents.
The one probably you're familiar, analog devices, little chip is patentable or?
The content of that chip may well have some patented technology.
Okay.
But the fact that it's a chip doesn't make it patentable,
Okay.
at least not in the last 30 years. There was at one time a number of people who come to us and said, we have this new invention. And what is it? Well, it's an operational amplifier. Oh, what's new about it? Well, it's in an integrated circuit. I said, well, did you invent an integrated circuit? Or did you invent an operational amplifier? He said, no. All we did is we took an operational amplifier and integrated it. Okay, next step. Was there anything you did when you integrated that operational amplifier which somebody who knew anything about integration wouldn't know how to do it? And he said, well, no. They didn't get the patent on the integrated operational amplifier. Now,
So miniaturization.
miniaturization is generally not per se patentable. There may be some aspects of how you miniaturize, such as how you do the layout. You may have figured out how to take up less real estate by the way you do the layout, and it's very tricky to claim it. But I have gotten patents on denser circuits based on applying different rules than our standard rules.
Recent cases like that are usually protected by copyright better than.
There
So
is,
that's-
in fact, in U.S., as of a number of years ago, a new law called the Maskwork Act, which is like a copyright. It was designed to allow owners of layouts right to protect against copying of their layouts. Now, it hasn't been widely used. It has been used once. Brooktree used it once, I guess, against AMD, and they won. But I'm not sure that it's going to be very useful, because the way the law was written, there had to be an actual image that was copied, and typically what's reproduced is a duplicate net list, and a net list doesn't necessarily lead to a specific mask work. So there are some issues there. But there is the argument that a layout of a PC board or a chip is covered by copyright, or at least mask works. Does that answer your question?
So how do companies usually protect their chips?
They try to get patents on the circuitry that's embedded in it, or they try to get patents on the elements which are expressed in the circuitry. It's very difficult to get patents on ASICs, though.
It's very difficult.
Very difficult.
Like patenting chip is patented. So
There are Intel has like about 500 patents that cover various aspects of
The Pentium.
of the Pentium and the MMX, and well, even some of the processes that are used in their firmware are probably patented. But so does IBM. IBM just recently has announced that it's going to become a little more aggressive in pursuing license infringers of its patented PC technology.
But something you cannot do is like look and feel. Where
That's copyright, and look and feel is another
it's
issue.
Not patent, it's
Yeah,
copyright.
that's got a lot of press, and it's kind of it's not well thought out.
It's very messy.
Yeah, it's very messy, and it doesn't really. And there's no statutory basis for look and feel.
Right.
I mean, you've got to copy, and look and feel is not copyable.
Well,
You are free to copy ideas under copyright law. You are not free to copy expressions of ideas.
expression of idea. How do you differentiate?
This is an expression of an idea. If I stick it in a photocopy machine,
Implement.
it's a copy. But if I say, is there an advantage to retaining individual ownership? That's the copyrighted material. And I restate that, can somebody own something as an individual? That's not a copy. That's a restatement. I'm using the same idea, but it's not a copy.
Okay, so you cannot write that.
I have a general concern.
You can have a
These days, you lawyers or attorneys try very hard to make the claims as solid, as broad as possible. And there are many millions of people doing the same thing. And then the patents accumulate at a very fast rate. Then one day, I mean, theoretically, it's very hard to make a claim that if you do every bit of search, very thorough search, you couldn't find anything very close to it. So patent, theoretically speaking, can be, it's somewhat duplicate of a previous work. Because everybody's making claims so broad and so...
Okay, let me separate claims from disclosure. Claims are a definition of what the scope of the invention is. Claims are not prior art. It's the description which underlies the claims which are the prior art.
Okay.
So the claims, as you say, look very broad, but the wording of the claims is very critical. One word can make a difference. One word can make a difference. Now, the issue that you raise is a legitimate one because it's very difficult to search the state of the art for concepts. Examiners do the best they can with the resources they have, but their resources are limited. Their time is limited. So patents may issue based on the art that they have before them, which based on that art is valid. But when compared with a full search of the art, which the examiner can't do because he doesn't have access to everything that's in the public, the patent may be found to be invalid. For those purposes, there are several procedures. If you, as a patentee, become aware of art that the examiner did not consider, you can go through a procedure called a reexamination and have your own patent reexamined against this art. If you are an accused infringer or even a third party, and you find art that could invalidate the claims of a patent, you can pay the patent office to reexamine it. You can't participate in the procedure of reexamination, but you can bring it to the attention of the examiner and make it of record. And then the examiner has to make the decision whether or not it's relevant. And third, if you are sued as an infringer, you can bring that art before the courts in normal common law procedure in the federal courts in the United States, or even in the courts of law in England. And I think there's a special patent court in England, by the way, and have that art considered against the patent to determine the validity of the patent.
All these costs, so...
all of these costs, yes.
Practical implications that pursuing this kind of a matter may or may not be worth very much.
It may or may not, but it does allow those with the resources to challenge the validity. Now, actually, re-examination is fairly inexpensive as patent costs go. The fees are under $2,000 American dollars to file and request it, and that's very cheap by American standards. It hardly pays for the cost of the examination.
Who are these people at the patent office? How specialized are they?
Some are more specialized than others. In the chemical arts, you often have PhDs who love to pontificate, as we heard this morning. Typically, they have at least degreed engineers. Many of them have been trained. They're civil servants. Many of them are foreign-born. Many Vietnamese, many Chinese who are actually trained engineers. Here's a great opportunity to go in and get further training and use the technical knowledge. And they will go on, and they have generally at least a 4-year degree. Some of them actually have gone to law school. In the electronics arts, very few of them have more than a bachelor's degree. In the chemical and biotechnical arts, many of them have PhDs. And some of them have developed a considerable level of experience because I've spent a lot of years in the patent office staring at this at a very narrow collection of prior art, and so they have some experience just by reading it.
In the area like I'm in wireless communication, there are about 10 conferences every year. There are about proceedings about that. It's like every year. These officers at the patent office can follow all this. I cannot.
No, they don't necessarily follow the conference proceedings. But if you look at those conference proceedings, from the standpoint of what an invention is, very few of them describe an invention in a way that is enabling, so it can be used as prior art.
Sorry, could you clarify?
They will talk about what they did, but they'll talk around it. They won't say what they did. Often they will file a patent application simultaneously which describes exactly what they did. The patent examiners get to see the patents. They don't necessarily have to look at the papers.
So, in other words, because we didn't do, say, our background research, okay, it just happened that we filed a patent, and it turns out that after the government grants the patent to me, somebody else say, hey, I did this 3 years ago, okay? Now, upon re-examination, that's correct. Am I being charged is there a crime? That's not a crime.
No, nothing.
So you just invalidate the patent.
It just invalidates the patent. It means the grant goes away.
The grant goes away, and then actually there cannot ever be a patent because that has been
now it's in the public domain.
In the public domain for 3 years. So
right. Yeah, and it's assuming the guy who did it 3 years ago published it, because if he didn't abandon it,
right.
or if it's abandoned, suppressed, or concealed, if it's a secret, the guy who gets the patent gets to keep it. Now, he may not be able to enforce his rights against the other guy because he has some rights because he's already been practicing it, but he can enforce it against everybody else.
When you say published, it means anywhere in the world that is published.
In theory, yes. In theory, including the internet.
Including the internet.
Now, the problem with the internet is how easily is it indexed?
It's very tough. Like what Sean said. I mean, how, do you index that 10 whatever volumes of conference proceeding every year? I mean, we accumulate knowledge. I think it's faster than what we could digest and process.
We haven't seen any citations to publications that exist only on the internet yet. At least I haven't. But I would assume that something that's available on the internet is qualifies as a publication.
Yeah, because I guess Alta Vista is pretty close
to that. Yeah, it's very close to that. Alta Vista has other problems.
Well, yeah, I know.
And the problem that I think about Alta Vista is that, is it infringing anybody's copyright by developing that huge index?
It's kind of scary.
But I'll just randomly poke around using Alta Vista, and gee, there I am.
Yeah.
In fact, there's my entire genealogy.
I think this morning you mentioned one point about the peer review process. I noticed that some NSF grants are very lengthy and in detail. And I'm from Canada, and NSERC has a similar process in Canada. How do I know there is a non-disclosure condition associated with the review of my proposal or someone else's proposal?
I don't know. I don't know the details of how those work, but sometimes those NFS grant proposals are in fact available to the public
because of a law or some other
because
law
of some law.
Okay.
Ideally, you don't disclose anything if it's your own NSF grant proposal. You don't disclose anything which is proprietary. That's the ideal situation. You talk about what the area of research will be and what you hope the results will be, but you do not disclose that which you think is proprietary for a peer review. Subject to, and I think you can, and your contracts administrator may be able to help you on this, you can possibly impose a restriction on the circulation of the material so that you do protect your proprietary rights.
Well, in Hong Kong, the usual granting agency, they are not very sympathetic about the non-disclosure agreement. So we did try to do that, but usually they would rather not read the confidential agreement and have the burden of signing that non-disclosure agreement. So that's the usual case. And I have also asked the granting agency, and the reviewer is not required to sign any non-disclosure agreement with the granting agency
So-
when they review the proposals.
Yeah. So
That's a
in
tough
that
one.
case,
Yeah.
if you have disclosed proprietary information,
Mhm.
and it's your problem.
Yes.
No,
So then
there's a way around that, and it's not a very good solution, and that is to file a patent application before you
You
make
write
the
a proposal.
before you write.
but you haven't done the work. You just have an idea.
Right, right.
Then that's okay.
And also, is it true that in the States, if it is a government-funded application and it's got funded, then the application becomes a public property?
Not
And
necessarily.
anybody can just go up to the funding
Not
agency?
necessarily.
No?
It depends on the particular agency. Health and Human Services has one policy. Defense Department has another policy. The Defense Department pretty much grants to the contractor all of their proprietary rights if they ask for it. Health and Human Services tries to retain rights but will release it. I would have to look at the specific contracts of the agencies, but there are conditions under which you can receive federal funding through the United States government and retain the rights.
Okay.
Another question, since you are in Silicon Valley, the engineers move around a
Yeah.
lot. So
A
how
lot.
do you know their ideas belong to whom? How do you prove this?
Very difficult.
Very tough, very tough. In fact, it's often the obligation, first of all, each of the engineers who moves around signs a non-disclosure agreement and an agreement to assign with each of his employers. And when he leaves, he usually has an exit interview, and he lists those things, or there is some agreement as to what he worked on so that both sides are aware of where their hot buttons are. Sometimes that doesn't happen as cleanly as it might, and maybe 3 or 4 people form a Seek and then run off from Intel and form a new company, and they get sued. And ultimately, they're proved right that they didn't take any proprietary information, but in the meantime, they lose a lot of money and
There is a
time.
line which is quite general. Should be a general guideline between the proprietary knowledge and the general knowledge.
Yes.
Because you gain experience, you definitely know more.
Yeah,
Not
exactly.
everything you bring. You start a new company, leaving Intel. Maybe you can do better than Intel. So
Exactly, exactly. And the California courts are very aware of that. And they say that general knowledge gained as a result of experience in the industry belongs to the individual. It does not belong to the company.
Okay.
So a company has to show specific instances in which information which is proprietary to them is used. A classic case was about 25 years ago when I guess it was Motorola sued Fairchild Semiconductor. And in the course of the trade secret litigation, there was a procedure of discovery where they went down and looked at Motorola. Motorola had listed all of its trade secrets. And he said, okay, Fairchild asked Motorola, okay, name your trade secrets that you think have been stolen. And they came up with a list of like 75 different trade secrets. Well, the lawyers went through and knocked out every one of those trade secrets, showing that they were either in the public domain or that they'd been published or that Motorola hadn't taken steps to protect them. I mean, out of 75, maybe 2 or 3 were defensible trade secrets. Motorola lost the case. Other questions?
I think we have quite enough today for
Okay.
digestion. Thank you very much.
Thank you. Yeah.
Thank you. Thank you for coming.